The certified letter arrived on a Tuesday. I remember because I'd just gotten off the phone with my contractor, the one who'd spent 6 weeks repairing the private access road that runs across my property. $63,500. That's what it cost me. Not because I wanted to fix it, because the HOA sent me a violation notice threatening daily fines if I didn't. I fixed their road, on my land, with my money, and when I submitted the reimbursement request they had promised me in writing, the board president, a woman named Darlene Whitfield, sent back a single sentence. This matter has been reviewed and denied. No explanation, no appeal process, just denied. What Darlene didn't know, what none of them knew, was that road sat on an easement, my easement, and the moment they refused to pay, they lost the right to use it. Every single one of them. My name isn't important. What matters is the property, a 2.5-acre parcel I purchased 11 years ago on the western edge of a private lake community called Harrowgate Shores. There was a recorded easement, a private road easement, running along the northern boundary of my lot. This gravel access road, about a quarter-mile long, connected the back sections of the community to the lakefront. Then we had back-to-back winters that destroyed it. 2 seasons of freeze-thaw cycles, combined with heavier-than-usual boat-trailer traffic, turned that gravel road into something that looked like the surface of the moon. Darlene called me 3 days later. I still have the voicemail. Her tone was the kind of patient condescension you use with someone you've already decided is beneath you. Mr. I'm sorry, what was your name again? That pause, that deliberate pause before she pretended not to remember my name after 11 years of living in the same community. That was the moment I decided this wasn't going to be a friendly negotiation. I pulled out the easement document. I read it carefully. Then I had my attorney read it. Then I had a second attorney read it, a real property specialist I found in the city, someone who handled easement disputes for a living. Her assessment was unambiguous. The original easement agreement contained a clause that had apparently been forgotten or ignored for decades. If the HOA failed to contribute to documented extraordinary repair costs upon written request, the landowner retained the right to revoke easement access with 60 days written notice. I received a violation notice. Not a response to my proposal, a violation notice, stating that the access road, which again ran across my property, was in a state of disrepair that constituted a nuisance under the community's CC&Rs, and that I was required to complete repairs within 90 days or face daily fines of $150. They cannot use a legal document to compel someone's compliance while simultaneously refusing to honor their own obligations under that same document. My attorney used the phrase, estoppel. I just called it what it was, a trap they'd set for themselves. I hired the contractor. I did not wait for the board. I did not ask permission. I scheduled the work. I supervised it personally for 6 weeks, and I paid every invoice the moment it arrived. Final total, $63,540. I documented everything. I have photographs of every phase of construction. I have time-stamped drone footage of the road before, during, and after. 12 days later, I received Darlene's response. This matter has been reviewed and denied. One sentence, no explanation, no legal basis cited. My attorney sent it to the HOA's registered agent, to Darlene personally, and to the management company. It outlined the easement agreement, the board's obligations, my documented repair costs, and the legal consequences of continued noncompliance. It came out, through the questioning of a homeowner who happened to be a retired CPA, that the board had received my original cost-sharing proposal, had voted internally to reject it without documenting the vote in meeting minutes, and had never consulted the HOA's own legal counsel. The room shifted. You could feel it. These were people who had trusted this board to protect the value of their community, and they were learning that the board had created a 6-figure legal exposure because the president didn't want to share a road repair bill. Darlene did not look at me once during the entire meeting. 3 days later, Keith Farrow from the management company called me again. This time the tone was different. The settlement was signed 6 weeks later. $31,770, wired to my account. The easement amendment was recorded with the county. In the settlement agreement, at my attorney's suggestion, we included a clause requiring the HOA board to send a written acknowledgement to all 47 homeowners summarizing the dispute and the resolution that Darlene had to sign. I still live at Harrowgate Shores. I still walk past that road every morning. It's smooth now, well drained. It'll last another 20 years if it's maintained properly. Sometimes the most powerful thing you can own isn't a house, it's a document.